Okay. So we have counts 3 and 4 are trafficking in drugs and possession of drugs. Those are each 5th degree felonies. Count 5 is trafficking in a fentanyl related compound, and count 6 is possession of fentanyl related compound. Count 7 is trafficking in a fentanyl related compound, and count 8 is possession of a fentanyl related compound. Those are all 1st degree felonies, meaning that they are punishable by up to 3 to 11. That's the minimum term, and the maximum term with the Reagan Tokes is up to 16 and a half. I'm doing my math wrong. Up to 16 and a half years were they to keep you to the maximum penalty. So moving on, we have counts 8 is possession of a fentanyl related compound as a 1st degree felony. Count 9 is trafficking in a fentanyl related compound as a 2nd degree felony. Count 10 is possession of a fentanyl related compound as a 2nd degree felony. Count 11 is trafficking in drugs as a 5th degree felony. 5th degree felonies are punishable by anywhere from 6 to 12 months in prison. So we have counts 11 and 12, and then counts 13 and 14 are trafficking in a fentanyl related compound and possession of a fentanyl related compound. Again, count 13 is a felony of the 1st degree, and count 14 is possession of a fentanyl related compound. That's a felony of the 4th degree.
So you're saying when I do get a judicial, I'm gonna be on post-release control, not probation?
If you serve your entire sentence, then you would be on post-release control. If you are released on judicial release, that means that you would be on probation. Is this what you want to do?
Yes, sir.
Mr. V, what are the facts?
Your Honor, if the case were to proceed to trial, the state would call as witnesses Detective Gregory Spannell, Warren County Drug Task Force, Detective Dan Schweitzer of the Warren County Drug Task Force, Sergeant Brett Lee of the Ohio State Highway Patrol, and Todd Yoke, criminalist from the Miami Valley Regional Crime Lab. Testimony from Detective Spannell would indicate that in the days leading up to July the 18th of 2025, he developed information from a confidential informant that the defendant, in this case Curtis Everhart, then using the name Future, was involved in the sale of fentanyl. Detective Spannell engaged in both text and telephonic communication with the defendant and arranged for the purchase of a bulk amount of fentanyl. They made arrangements to meet on July the 18th of 2025 at 2830 State Route 123 in Franklin. That's located in Warren County in the state of Ohio. And they are engaged in a hand-to-hand transaction in which the defendant provided to Detective Spannell 11.9 grams of what was tested to be fentanyl-related compound at the Miami Valley Regional Crime Lab. That testing also indicated the presence of xylazine, a Schedule III controlled substance. The contact with the defendant, both by text and in person, was recorded. Following that, the defendant continued contact with Detective Spannell in regards to drug trafficking, and arrangements were made to meet again for the purchase of controlled substances on July the 21st of 2025. Defendant directed Detective Spannell to 2700 Miamisburg Centerville Road in Dayton. That's in Montgomery County, but a continuing course of criminal conduct that began in Warren County, Ohio. There they met and again engaged in a hand-to-hand sale of what was later tested to be 20.3 grams of fentanyl-related compound. Again, the contact by text and in person was recorded. Following that, the defendant and Detective Spannell again communicated and made arrangements for the purchase of fentanyl on August the 4th of 2025, again at 2700 Miamisburg Centerville Road. That's in Dayton in Montgomery County, but a continuing course of conduct that began in Warren County. Defendant and Detective Spannell again engaged in a hand-to-hand sale of what was tested to be 28 grams of a fentanyl-related compound. On August 18th of 2025, again, the defendant made arrangements for a sale of fentanyl to Detective Spannell. They again met at 2700 Miamisburg Centerville Road in Dayton in Montgomery County, a continuing course of conduct that began in Warren County. And then they again met and exchanged for the purchase of what was later tested to be 13 grams of fentanyl, a Schedule II controlled substance, and also tested positive for xylazine, a Schedule III controlled substance. Again, the contact with the defendant, both by text and in person, was recorded. And finally, on September the 3rd of 2025, officers made arrangements for a buy, bust, and execution of a search warrant. Defendant made an offer by communication with Detective Spannel, offered to sell him 1 ounce, that's 28 grams of fentanyl, for $800. Defendant's vehicle was stopped, and he made an indicated to Detective Schweitzer as well as to Detective Spannel that he had intended to fleece Detective Spannel, that he did not have that fentanyl in his possession. A search of his residence, though, did locate 2.5 grams of a fentanyl-related compound. The defendant has a prior conviction for a drug offense. That's possession of heroin, Butler County case 2017 CR 20197.
Anything on those facts, Mr. Kirby?
No, Your Honor.
Mr. Everhart, did you hear all of those facts?
Yes.
Do you admit that they are true?
Yes.
Do you understand the rights that you're giving up by entering a plea of no contest?
Yes.
Is this what you want to do?
Yes.
What's your plea?
No contest.
I'm going to accept your plea of no contest. I think it's been made in a knowing, voluntary, and intelligent fashion only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. Anything additional on the facts, Mr. View?
Nothing additional on the facts, Judge.
Mr. Kirby?
Your Honor, for the record, we would waive any formal pre-sentence investigation and elect to move forward with sentencing today. If I could be heard on sentencing, Judge.
Okay, I am going to find Mr. Everhart guilty of all 14 counts. Before we go into the matter of sentencing, we have a couple of issues that we have to resolve. First of all, we have the notifications regarding the Reagan Tokes. Mr. Everhart, you had the opportunity to review the notification sheet with Mr. Kirby prior to the hearing today, right?
Yes, sir.
All right, we're going to go ahead and give Mr. Everhart this notification sheet right now, or does he have it already? All right. Secondly, we have the issue of post-release control. There is a mandatory period of post-release control of anywhere from 2 to 5 years. That means, Mr. Everhart, if you serve your entire sentence, the adult parole authority is going to supervise you from that 2 to 5 year period. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. We also have this notification that I'm going to provide to you, and we're going to attach the Reagan Tokes notification as Exhibit 1. We're going to attach the post-release control as Exhibit 2. But again, you have those and you can take them both with you. Second issue we have is I have an affidavit of indigency, which is executed by Mr. Everhart. So I find that he is indigent for the purposes of fines and costs in the case. Next, we have the issue of merger. It is my belief that counts 1 and 2 merge, 3 and 4 merge, 5 and 6 merge, 7 and 8 merge, 9 and 10 merge, 11 and 12 also merge. Any dispute from the state on the issue of merger?
No, I agree with those, Your Honor.
Any dispute from the defense on the issue of merger?
No, Judge.
Essentially what this means, Mr. Everhart, is each time that you are charged with trafficking and possession, those counts merge, the possession will move into the trafficking, and the state is proceeding on the traffickings, right?
Yes, Your Honor.
All right, so in
Yeah.
counts 1 and 2, 3 and 4, 5 and 6, 7 and 8, 9 and 10, 11 and 12, you're only going to be subject to a sentence in the trafficking, not in the possession. Okay? All right. With regard to sentence, do we have a jail time credit figure?
246 days as of today, Judge.
All right. Mr. View?
Nothing additional on it. I think we've covered everything in terms of what the court intends. I just if you would let me know which counts you intend to impose the sentences on, then I'll prepare the sentencing entry.
All right, Mr. Kirby, what do I need to know about this?
Judge, I agree with the 246 days of jail time credit. As Curtis indicated, he's 35 years old. He's from Middletown originally. I think that Curtis had an upbringing that makes him vulnerable for very bad situations like this case. He does want to put this behind him. He wants to maximize the time that he will spend incarcerated. I've already spoken with him at length about that. He intends to get his GED while in the Department of Corrections, along with other appropriate rehabilitative activities. He's already alluded to potentially a future motion for judicial release. Curtis has been a pillar in this family.
Ha, 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 ha.
He's been very helpful for her. He has a niece, he has other family members, an aunt that miss him and love him and provide an excellent support to him. His father was uninvolved in his life. His mother passed in 2017. That was a hardship on the family. And she has personally vowed that she will undertake helping Curtis out upon his release whenever that time is. Your Honor, we did provide the court with an executed affidavit of indigency. We would ask the court to waive the mandatory fine, credit him the time served, and impose a minimal sentence. That's all.
What do you want to tell me, Mr. Everhart?
All I can say is I'm sorry, and I didn't mean for this to come about, and it's just, I'm letting a lot of people down being in this situation, and I apologize.
All right, the court is going to impose a prison sentence. There is a mandatory prison sentence that goes along with this. So it would be counts 1. Let me make sure that I get this right. So it'd be counts 1, counts 5, count 7, count 9, and count 13. The court is going to impose a 6 to 9 year prison term. That is a 6-year mandatory prison term. And you're going to also receive the indefinite sentence, which is that 3-year Reagan-Toke sentence. So you're going to receive a 6 to 9 year prison sentence. I'm also going to, on count 3, sentence you to 12 months in prison. Count 11, sentence you to 12 months in prison. And on count 14, sentence you to 18 months in prison. And I'm going to require that all of these be served consecutively, because a consecutive sentence is necessary to properly punish you. Your criminal history suggests that a consecutive sentence is necessary to properly protect the public, and the overall sentence is not disproportionate to the conduct involved here or the danger posed by you. So the total would be a 9.5 to 12.5 year sentence. I do find that you're indigent for the purposes of fines and costs, so I am not going to impose any financial sanctions. We've already talked about the post-release control. You're subject to the mandatory post-release control. You are eligible for judicial release at some point in the case, and you have the right to appeal this.